Ladies and gentlemen, all of you are here tonight with one common concern, and that is that you have seen, and with your own eyes you have heard with your own ears, those situations which make you uncomfortable as to the continued preservation of your liberties. And I know for years you have wondered why it is we go to the polls year after year after year. We vote for different people. We keep sometimes people who seem to be doing a good job, but in the end, here we are in our 30s, 40s, 50s, and it hasn't worked yet. What's going wrong? The answer to that is fairly simple. Starting with the time when our fathers came home from the Second World War, the quality of our education was intentionally demoted. And critical pieces of information were left out. Today, there is not a child leaving high school, turning 18 years of age, walking off that stage with a diploma, understanding that the next morning he is going to take a seat on the board of directors of the biggest corporations in the world, the United States of America and the state of Georgia. Board of directors. It is his duty, her duty, to apprise herself, how is this system functioning? How is this corporation paying dividends to us who are on the board of directors? After all, it's our money that is being invested in this. They don't know. They don't know what to do because they have not been taught that the ultimate power in this republic today, it may not be this way long. All it's going to take is a constitutional amendment in the state of Georgia, and you can kiss your liberty goodbye, and you can start kissing the fanny of your public servants who will become your masters. Every one of you, please, get your Georgia Constitution. Read it for yourself. Read Article 1, Section 1, Paragraph 11. Read and understand what it means when a criminal trial jury and a grand jury are the only two entities in this nation every constitution, I don't care which one you pick up in Georgia, criminal trial jury, grand juries, judges of the law. There is no greater power. And that power is left in your hands when you are sworn in as a grand juror. Surely there must be some rein on that kind of power. Well, yeah, there is. In the case of U.S. v. Calander, the United States Supreme Court observed that there's one thing the grand jury cannot do. It may not deprive one valid entitlement, one valid right, whether it is established in the Constitution, in the statutes, or in the common law. Other than that, in the proper performance of their duties as prescribed for them in their oath. A grand jury answers to nobody. They do not answer to a district attorney. They do not answer to a governor. They do not answer to the Supreme Court justices, and they do not answer to a Superior Court judge. District attorneys and Superior Court judges, governors, legislators, the Attorney General of the state of Georgia serve the grand jury in this state. This is not true in every state. Georgia is one of 2 states that I know of. I think there are 2 more states, but out of the 50, those 4 are the only ones who acknowledge the power of a grand jury. And Mr. Cosby asked me to address this point, and I'm fixing to do so right now. House Bill 941 attempts to modify the code provision which allows a law enforcement officer charged with excessive use of force or charged with any violation of his oath of office to appear before the grand jury. And now they want him to have to give his testimony and be subject to cross-examination. Heretofore, he didn't have to go through cross-examination. He could sit up there and cry and carry on and intimidate with the force of his personality or the sadness of the situation that he's gone through and intimidate a jury into cutting him loose, not presenting him for whatever crime he may have committed. Yes, sir.
Who's going to cross-examine?
Now you see, it's probably going to be the district attorney, and if that's the case, he's, in some cases, I can tell you from personal experience, from personal investigation, there are a lot of corrupt district attorneys in this state.
There's only one side presented in front of the grand.
That's correct, it's the prosecution.
Not only that, Judge, if an officer is sitting in there, he can modify his testimony to match what he may hear in the grand jury.
Good point. That's an excellent point, because he has an opportunity to modify and to present facts in a slightly different light than he may have intended to. But I don't wish to get into the technicalities of that. Here's the problem with that piece of legislation. And there's another statute in Title 45 which allows public officers the same entitlement to go sit and listen to the evidence being presented and then make a statement. Now, both of those are unconstitutional laws. Well, how do you get that? It's simply this: first, equal protection.
That's right.
Public officers and employees are not entitled to protections you, the citizen, are not entitled to. Now, there are court cases that have pretty much settled the attitude of the appellate system in this state about equal protection. And they're taking your equal protection concerns and throwing them in the trash can and saying, basically, well, elected public officials have a compelling state's interest in not being unnecessarily tied up with litigation so they can get on with doing the duties of their office. You can decide for yourself whether or not that concern supersedes your equal protection under the law.
So, Paul, you're saying that this bill is going to give extra constitutional rights to police officers?
No, it will not give extra constitutional rights. It's what's called a statutory entitlement. But here's the problem with the whole thing. There are 4 courts in this state. You have the Article 6 court. You have the Article 5 court. You have, which is generally referred to as administrative law courts. You have Article 2 courts, which is the legislative court, court of impeachment. Then you have Article 1 courts. In Article 1 courts, you have a trial jury and you have a grand jury. Guess what? And the other three judicial, quote-unquote, systems, the state legislature has the authority to exercise legislative discretion to enact laws that it believes are necessary and proper to administer those courts. Guess which court they do not have legislative authority over? Article 1, the grand jury and the trial jury. Those duties, those responsibilities, those processes, procedures, practices and procedures come out of the common law. Thank you.
Okay,